So this session will be about 1 hour and 15 minutes. It will be a conversation between our two speakers. Please remain on mute until we open the conversation for a Q&A. But feel free to write down your questions in the chat. So today we're focusing on the recent request by the ICC to issue arrest warrants for Prime Minister Netanyahu and Defense Minister Galant. And our great speakers will discuss why this request is so significant, why it symbolizes a shift in the way the international community is addressing the Israel-Palestine conflict, and what are the potential short and long-term implications. And Dr. Sigall Horovitz and Dr. Ofer Shinar Levanon, our speakers, will also talk about the idea of transitional justice and how it can be an alternative to the ICC involvement. Now, I know there are a lot of kind of legal terms, and I have told them that our audience are mainly non-legal individuals, so they're aware and they will explain everything, so bear with us. Dr. Sigall Horovitz is an academic advisor of the Fried-Gal Transitional Justice Program at the Clinical Legal Education Center of the Hebrew University of Jerusalem. Her interest areas include transitional justice, international criminal law, anti-corruption law, and ethics. She initiated transitional justice programs at the Hebrew University and Tel Aviv University, where she led study trips to Rwanda and South Africa. And she's currently joining us from Vienna. And so she will be in conversation with Dr. Ofer Shinar Levanon, who is a member of the We Democracy community. Ofer is a former lecturer on the psychology of the Israeli-Palestinian conflict and international law at the Hebrew University. He was a research fellow at the International Center for Transitional Justice and head of research at the Bereaved Families Forum. So thank you so much for being with us today, and I'll hand it over to you.
So Sigal, allow me to start. First of all, I want to say that Sigal is also not only a former colleague, but a really, really good friend. I'm very, very happy that she had agreed to be part of our sessions of lectures. And Sigal, without further ado, I would like you to suggest what happened in May, recently as May, with regard to the ICC, Israel, and Hamas.
Okay, thank you very much. So maybe we outline the purpose of the talk, which is, what happened in May with the ICC and what's going on. What is the role of the ICC in relation to the Israeli-Palestinian conflict, and particularly the ongoing hostilities in Gaza? And you've asked me now what actually happened. I think after we outline this, you'll have more questions, but this is the framework to understand what's going on. So very recently on the 20th of May, the prosecutor of the International Criminal Court has announced that he has applied to the judges of the same court, asking them to issue arrest warrants of arrest against 5 persons, including 3 leaders of Hamas and 2 Israeli leaders, the Prime Minister Bibi Netanyahu and the Defense Minister Yoav Galant. And he's requested the court to issue arrest warrants for these individuals for alleged war crimes and crimes against humanity that they allegedly committed with regard to the current hostilities in Israel and Gaza. Now, this didn't come out of nowhere. I can give more information about the exact content of the allegations if you're interested later. But the allegations didn't come out of nowhere. It is basically the consequence of an investigation that the International Criminal Court has started in March, 3 years ago. So on the 3rd of March, 2021, the former prosecutor of the ICC, the International Criminal Court, initiated an investigation in the situation of Palestine. And that is defined as crimes within the jurisdiction of the ICC. These are war crimes, crimes against humanity, and genocide that are alleged to have been committed in the situation of Palestine, which I will elaborate what that means, since 13 of June, 2014. So all the alleged war crimes, crimes against humanity, and genocide that may have occurred or have alleged to have occurred since the 13th of June, 2014, so 10 years ago, are covered by this investigation. The situation in Palestine has been defined as the crimes I've enumerated that have been committed in the territory of Palestine, which is considered by the ICC to include the West Bank, including East Jerusalem and Gaza. So any crimes against humanity, war crimes, or genocide allegedly committed in that geographical area comes under the investigation of the ICC, as well as any crimes committed by Palestinians, so-called nationals of this state of Palestine for the purposes of the ICC. So Palestinians from West Bank, Gaza, East Jerusalem, any crimes they may have committed anywhere. So the jurisdiction follows Palestine territory and nationals, right? And obviously it concerns crimes that are listed and defined in the statute of the ICC, war crimes, crimes against humanity, and genocide. And the reason this jurisdiction starts in 2014 is because that is when Palestine, or the Palestinian Authority, has requested the ICC to start its investigation. And this request was made back in 2014. So it's just a procedural step taken by Palestine, and that determines the beginning of the investigation. But the first stage the ICC takes is a preliminary examination. So all those years from 2014 until 2021, when the investigation commenced, all those years, 7 years, there was an ongoing preliminary examination by the ICC prosecutor. All right, we could talk about what that means. Interesting maybe to note that within this time, the prosecutor felt a bit maybe insecure or confused or under some kind of a lack of precise idea about the territory of Palestine. And so within those 7 years, the prosecutor of the time requested, this was in 2020, beginning of 2020, the prosecutor requested the judges of the court to determine what constitutes the boundaries of the state of Palestine. And within a few weeks, in February that year, 2020, the judges came up with their decision, which is a majority decision, 2-1, that Palestine has the territory which encompasses Gaza, West Bank, including East Jerusalem, and that it is a state for purposes of the ICC. They went to great length to saying this is not a determination that it's a state for all intents and purposes, but just for the purpose of the ICC and its goals, Palestine is considered a state within those territorial boundaries. And so this happens in 2021, that she then commences an investigation. The investigation was it was ongoing, but we were not hearing a lot of very precise developments. It did not lead until recently to a request for arrest warrants. And then came October 7th. So October 7th attack and the ensuing operation or war in Gaza led the current prosecutor of the ICC within days of October 7 to announce and remind, first of all, everyone that his office has an ongoing investigation with jurisdiction over Palestine that goes back to 2014, and that any crimes committed in the territory of Palestine by any party are covered by this jurisdiction, and that any crimes committed by Palestinians outside of that territory is also covered. He also emphasized, this is in October last year, he also emphasized that his investigation obviously covers current events in Gaza and in the West Bank, he mentioned. A few days later, the prosecutor of the ICC arrived in Egypt. He visited the Egyptian side of the Rafah border of Gaza and Cairo, where he made an announcement. And in his announcement in Cairo, he reiterated that he's got an ongoing investigation, which now includes hostilities in Gaza and the events of October 7th, and called on everyone to kind of bear that in mind. A few weeks later, on 17th of November, 2023, the prosecutor received a referral of the situation in the state of Palestine from 5 state parties. This is another way that the ICC prosecutor acquires jurisdiction over cases, is if any state party, not necessarily Palestine, any state party whatsoever, that is a state party to the statute of the ICC, which is also called the Rome Statute. So he received from state parties, 5 state parties, South Africa, Bangladesh, Bolivia, Comoros, and Djibouti. He received from all of them a referral to investigate the current hostilities in Gaza, to which he replied and made a press release on this, that he confirms that his office is already conducting an investigation into the situation, which started in March 2021, and that this investigation encompasses everything that started from 2014 in Gaza and West Bank and East Jerusalem, and is ongoing and extends to the escalation of hostilities and violence since the attack that took place on October 7th, 2023. So he's very clear about this. A few weeks later, again, so this is bringing us to December 2023, the ICC prosecutor paid his first ever visit to Israel. He was invited by families of the hostages. And during this visit, again, he stressed the gravity of crimes committed in Israel on October 7th by Hamas and affiliates, referred to them as crimes which the ICC has jurisdiction over and which the ICC was established to address. And he also warned Israel that his office will be required to act. And I'm quoting him. My office will be required to act if Israel fails to comply with international law requirements in Gaza and the West Bank. And so this brings us to last May, where he issued his arrest warrant, or his request for arrest warrants. And I could speculate why he went and moved forward to this stage of arrest warrants, and why his investigation, even though it's going on for 3 years, that only now has yielded this request for arrest warrants. Of course, the gravity of the hostilities, but also focus areas of the ICC prosecutor priority areas include sexual crimes and crimes against children. And I think you felt that in this case, of course, both are part of what's going on. Also, probably the fact that hostages are still held in Gaza had made him sort of hurry up in hopes that the proceedings may influence the release of the hostages. Also, obviously, the high death toll and the humanitarian catastrophe in Gaza had made him act fast in order to maybe alleviate the situation and prevent further damage. I think he also may have been acting fast to scale down the increasing violence by Jewish settlers against Palestinians in the West Bank. And he stated now and again, I have to say, that his investigation is continuing and there may be other arrest warrants coming out. Probably the inflammatory statements by Israeli politicians. He wanted also to kind of send a message that they want to maybe be more careful about this. Yeah, this is the situation. The 3 Hamas leaders that have been subject to his request for arrest warrants are Sinwar, Deif, and Hania. And their allegations against them include crimes against humanity and war crimes committed on the territory of Israel and in the state of Palestine, particularly the Gaza Strip, from at least 7 of October. The allegations against Galant and Netanyahu include war crimes and crimes against humanity, in particular in the context of a a starvation or a policy of starvation in Gaza from at least the 8th of October last year in the territory of Gaza. Now, what remains is for the judges of the pretrial chamber of the ICC. So these are the judges that the prosecutor requested the arrest warrants from. So these judges, 3 judges of pretrial chamber 1 of the ICC now have to decide whether the necessary standards for the issuance of arrest warrants are met. And if so, they may go ahead and issue these arrest warrants.
So what do you think would happen? Would these arrest warrants be issued?
I mean, there have, in the experience of the ICC, most of these requests by the prosecutor have been met with the issuance of arrest warrants. You know, the allegations, the standard of proof for issuing arrest warrants is not high. It's not beyond reasonable doubt. It's only, you know, reason to believe. And we haven't seen the evidence on the basis of which the application was made by the ICC prosecutor to the judges. But it seems like he was very careful. He consulted with a panel of experts. He was very vocal about this. So it seems that there's a good chance that the arrest warrants will be issued.
I'm struggling whether you want to discuss the ICJ, because it would make it even more complicated. But I think we can escape just a brief mention of the proceedings before the ICJ and discuss the differences between the courts.
Yeah, I'm conscious of time. And I want to say, yeah, the difference between the courts are very important, because there is an ongoing case in the ICJ, but the ICJ and the ICC are 2 different courts. They're both based in The Hague. The ICC, International Criminal Court, that we have been discussing so far, is a criminal court, right? International Criminal Court. The ICJ, which is the acronym for the International Court of Justice, is a civil court. First of all, it's not a criminal court. So if you don't know anything, this is a criminal court, it's a civil court, but more than that. So criminal court obviously tries individuals for alleged crimes, right? That's what the ICC does, right? Specific crimes and specific places. But it still tries individuals for alleged crimes. It can convict them and send them to prison, right? The civil court, or the non-criminal court, the ICC, is also an international court in The Hague. It is a court that resolves dispute between states, right? It is a UN body. The ICC is not a UN body. The International Criminal Court is not a UN body. It has relationship with the UN, but it is established by a multilateral treaty. All right, that's the criminal court. It's not a UN body, and it's a criminal court. The ICJ, International Court of Justice, is a UN body. It is a court of the UN. It is there to adjudicate disputes between states. It has another role. It's sort of like a legal advisor to UN bodies. So if UN bodies have a legal question and they really can't figure it out, they ask them for legal advice. All right. But in most of the cases, and especially the case that we're concerned with, South Africa versus Israel, these are cases where states are trying to resolve their disputes before the ICJ. There's no prison sentences in the end. They can't send a state to prison, right? They can condemn or declare that a state is violating international law. They can impose reparations on that state. But they can't, the judges there can't give a criminal punishment to the state. In that court, the ICJ, South Africa has brought a case against Israel last December, alleging that Israel is perpetrating genocide in Gaza as a state, not individuals within Israel, but the state. So there's a question, of course, what is the relationship between individuals perpetrating genocide and the responsibility of the state to genocide? But that goes into a lot of legal issues that I don't think we have time for or appetite. But that's a case of South Africa alleging that Israel, in particular, is violating the Genocide Convention in its actions in Gaza. There's a genocide convention states are party to, and here there's an allegation that Israel is breaching that convention, and it is not protecting Gazans for genocide and or committing or having a policy or encouraging the commission of genocide in Gaza. And that's ongoing in The Hague as well since December. And we've had several, not arrest warrants, but several orders coming out of that court towards Israel to try to prevent certain actions in Gaza and to try to have access to more humanitarian aid going into civilians in Gaza.
And I think another difference with regard to Israel is that Israel is participant to the ICJ proceedings, while Israel is not a signatory on the ICC convention, the Rome Convention. And I'm wondering what would happen. Imagine that we are likely to have those warrants issued. What would happen next? Would Israel be willing or interested in providing defense? Would the ICC would be able to go on and to try these people without their participation?
Right. So we ended the previous explanation about the ICC with what's before the judges now, right? To issue an arrest warrant or not, right? And let's say they go ahead and do it. There is a possibility for the defendants or the relevant state to what we call challenge the admissibility of the case before the ICC on the basis of the principle of complementarity. And the principle of complementarity basically is an organizing principle of the ICC. It has many shapes and forms, but the gist of it, the idea of it, the philosophy of it is that the ICC is a court of last resort. The first chance to adjudicate international crimes rests with the state itself, with the concerned country. And only if the country does not do that will the ICC intervene, right? That chance is given to the state already since the ICC is seized of the case or of the situation, as we call it, from the outset. So already in 2014, when the ICC received the referral from Palestine and started its preliminary examination, part of what it does in its preliminary examination is satisfy itself, the prosecution does this in examination, it wants to satisfy itself that the ICC has jurisdiction and that the case will be admissible. So it proactively tries to assess whether the states concerned are or is initiating investigations or prosecutions into these alleged crimes. And there were years of this preliminary investigation where the prosecutor, I assumed, had been in communication with the Israeli authorities, or at least read what she or he could online in public resources about whether or not there are proceedings in Israel concerning these allegations. And I can only imagine that the investigation commenced in 2021 once the prosecutor had satisfied herself that no such proceedings were taking place on the domestic level. Once the ICC prosecutor initiates an investigation, and so this happened for Israel-Palestine in March 2021, the prosecutor announces this publicly and specifically sends an announcement to the states concerned, so Palestine and Israel in this case. And this, according to the Rome Statute, the state has a chance within 1 month of this announcement to declare that it is already investigating these charges or allegations of crimes that are crimes under the Rome Statute, war crimes, crimes against humanity, and genocide. And the state is open to announce this. There are some criteria. I mean, it can't just be an announcement and there's no basis. So there's got to be an ongoing process. And the process has to be referring or relating to the category of people the ICC pursues and the category of crimes the ICC pursues, right? So there are no specific names of people at that stage. But we know that the ICC goes after those with the greatest responsibility, and we know that the crimes the ICC pursues and addresses are war crimes, crimes against humanity, and genocide. So the state concerned has to apply and declare and show that it's already seized of the matter and having its own investigation, or that it already investigated and prosecuted, or that it investigated and the investigation led the state to a conclusion that there is no need for prosecution. And then there's also different qualifications and exceptions, et cetera, but we won't go into the legal niceties there. But if the state makes that declaration, then things are put on hold. There is a possibility for the pretrial chamber to assess whether there is a genuine proceeding taking place on the national level, and that if the decision is that the domestic proceedings are not genuine, the case goes back to the ICC. So the genuine nature of the proceedings is very important. But once the state gives this announcement, there's a little bit of a freeze and a hold, and things then go to the judges. Now, if that doesn't happen, and it didn't happen for Israel, right? So 1 month after March 2021, Israel did not make such announcement. Then what happens then? Can Israel still make an announcement that it is running these proceedings at home domestically? Yes, it can. But when? Not at any time. So once a case emerges out of the situation, right? We had the situation of Palestine, and a case emerges out of the situation, or several cases emerge out of the situation. When there are specific suspects and specific conducts that are now the focus of an investigation, or perhaps an arrest warrant request, or later on a trial. And once these cases emerge, it's not very clear at what point in time. Are we already in a case? The ICC hasn't yet given a case number to, there is no case against Netanyahu yet. But we know that there's a suspect, and we know that there are very concrete allegations, even though they're not approved yet in an arrest warrant. So it could very well be that there's a clear understanding of the contours of a case. It could be that perhaps the pretrial chamber's issuing of the arrest warrants will be the date we can consider a case for the purposes of complementarity challenges to come into play, or perhaps already now. There isn't a clear jurisprudence on this. But at this stage, the state or the accused can argue that it has already investigated and prosecuted, or it has investigated and decided not to prosecute, or it is right now investigating the same charge or the same allegations and the same suspects. So right now, it's not the category of suspects and the category of crimes, but these allegations that the prosecutor named in its request for arrest warrants, and these suspects that the prosecutor named have to be now the subject of a domestic investigation. For the state to argue that the ICC at this stage does not have, or the case cannot be admissible before the ICC. Now, the state can argue it now, or the accused can take legal counsel and argue it now, or they could do that when the pretrial chamber issues arrest warrants. If it does it now, there's a chance there will be no arrest warrants. I think there's a big stigmatization in this chance of arrest warrant being issued. Remember, when arrest warrants are issued, we're talking about pretrial chamber. So I didn't go into this before, but that can be appealed as well. So pretrial chamber can issue arrest warrants, and then concerned parties, so by then it would be the defendants, but it could be the prosecution in case it doesn't get what it wanted. The parties can appeal the pretrial chamber decision to issue arrest warrants, and then it goes to the appeal chamber. That's a different request than the request to activate complementarity.
I'm thinking, Sigal, whether we are discussing that in really minute details, why I really want to pick your brain with regard to what you think Israel is doing and should be doing. And also, I think about Netanyahu or Galant, just by communicating to the court, they basically acknowledge the legitimacy of the court, and they can just, I think, would not have any connection. In your experience, what are the common responses to ICC proceedings?
I mean, we have cases in the ICC. I'm thinking of the, I don't know, Darfur case. We've got arrest warrants concerning the former president of Sudan, Omar al-Bashir. We have arrest warrants concerning Putin. Obviously, these personalities are not before the court. They have not been apprehended. As far as they're concerned, they don't care about all this. They will have problems traveling to certain countries because an arrest warrant by the ICC obligates all the member states of the Rome Statute to apprehend the suspects or the accused people and transfer them to the court. And so we know that we know that Putin hasn't traveled to certain places because of this. Al-Bashir, the same. Al-Bashir has traveled to some places and they have not handed him over. So South Africa and Jordan and other places are in violation of the Rome Statute because they have not handed over a suspect or an accused to the ICC. Now, that doesn't mean that they're going to get any sanctions. That's another question. I don't think the state of Israel can afford to completely ignore. And I mean, it's a very small state. And in principle, yeah, I mean, Galant and Netanyahu, if they have arrest warrants, they may not wish to travel to certain countries, most of Europe, most of the world, basically.
But not the US, by the way.
US is not a member state. The US is very much engaged with the court. It's very involved in the current investigation in Ukraine. It's a big donor to the court, so I think the US cares about its relationship with the ICC, but it's not obligated to hand over a suspect. Israel has been engaged with the court in various ways. It has attended Assembly of State Parties as an outside sort of observer. It allowed the prosecutor to enter Israel in December for his visit. It didn't invite him. He was invited by the families of the victims, but it gave him the visa, so the country has had a relationship and has a relationship. I don't think it wants to be viewed as completely sort of ignoring arrest warrants. I think Israel will try to fight this in ways that are using the law and using the Rome Statute and perhaps even providing new facts that may, I don't know, propel the prosecutor to withdraw or change the charges. If we're talking about a starvation policy and it's based on lots of statements made by high officials in Israel in the first days after the October 7th attack, plus the situation in Gaza, but Israel may say, we're not starving them. We're letting in humanitarian aid. It is Hamas that's grabbing that aid for itself. And we just threw out some angry words, but we didn't mean it. If Israel can prove all that, and I would imagine that it was not cooperating very much with the prosecutor until this point, but maybe it may want to complete the picture and provide more evidence. It's open to do that. And the prosecutor may say, okay, in light of new information, I withdraw this request, or in light of new information, I change my request. Now, don't forget that there's an ongoing investigation. We might see further charges or further requests for arrest warrants with charges against new people and with relation to new events. It could be even West Bank conduct that is under scrutiny this time. And I think this is a very pertinent point for Israel. And it's in a position where complementarity can be activated in various ways in order to prevent even a request for arrest warrant by the prosecutor. And if we're talking about mapping out, Israel is already mapping out incidents in Gaza in terms of where have there been sort of large scale, death and destruction of civilians. And the military has established an independent inquiry mechanism that is looking into that. I think several criminal proceedings have already started. There's talk about an inquiry commission, a national commission of inquiry, which may also target the responsibility of leaders. I think all those steps are steps in the right direction, especially with regard to unnamed suspect and unnamed accusations. I believe also, and Ofer, you're going to ask me next about transitional justice, and I believe that these kind of criminal and military adjudicative processes could be complemented by non-judicial transitional justice mechanisms. We'll go into that. But I believe at this point, it would be useful for Israel to use transitional justice approach as a complement to a commission of inquiry and to the military investigations. And I'll wait for you to ask me why I think that. So there's an array of steps that Israel can take with regards to the two people named in the prosecutor's application. And that is show more evidence why they shouldn't be there on this request. A. Secondly, activate complementarity. Start now to investigate them so that when the case actually starts officially, when arrest warrants are there and, the procedure is clearer, you can say already that there's an ongoing investigation, because Israel will not be able to say at that stage when arrest warrants are approved that it intends in the future to start an investigation. That will not fly. So there's lots of jurisprudence already on that by the ICC, that an investigation has to already be ongoing when the case starts in order to activate complementarity at that level, in order to argue that the state is doing the adjudication and the investigation. And by the way, the state has one shot to argue that it's doing at home the proceedings. So that one shot better be right. And that they better have already an investigation in place. It doesn't mean that prosecutions are going to happen, but you'll have to have an investigation in order to decide that. So for all intents and purposes, investigation now, so that in a month's time or so, it doesn't take the chamber very long usually to respond to a prosecution request for arrest warrants. So when there's a response, and if that response is positive, Israel wants to be in a position to say that there's an ongoing investigation going on, and that is the type of investigation that can lead to criminal proceedings. So even if we have an inquiry commission, there's now a live debate on the blogs, whether an inquiry commission, a state commission of inquiry is going to be enough or not. If it's a mechanism that can lead, or that is the way to lead to criminal investigations and criminal proceedings, then it should be able to activate complementarity. So that's where like a TRC or a transitional justice mechanism has a weakness at this point, because it's not a mechanism that will a priori or that is conventionally the one that leads to criminal prosecutions. But in the case of Israel, one can argue that an inquiry commission may be the type of investigation that leads to criminal proceedings based on practice, based on history. But that would need to be argued, because the classical mechanism for that is criminal investigation.
So you're basically saying we haven't really discussed transitional justice, but whatever Israel would suggest it's doing, it has to suggest doing it right now. So if Israel is interested in doing anything else, which is a commission of inquiry or transitional justice or whatever, it has to do it right now.
Exactly. Israel has to be in a position when the pretrial chamber approves the arrest warrants currently being requested. At that time, which could be in a few weeks, Israel has to be in a position to argue that it has an ongoing investigation which addresses the same people and the same conduct. The conduct doesn't have to be characterized as a crime against humanity, by the way, because we don't have a law for that in Israel. It can be characterized as a domestic violation, but it's gotta concern the same conduct of activity, the same kind of group of activities that the ICC is concerned with, and definitely the same people. This is for the arrest warrants being requested now. For future arrest warrants being requested, we don't know against who, and we don't know what they will be, and therefore it's a broader net that Israel can cast. But I would advise to do it now, obviously, to be in a position to argue that an ongoing investigation is going on or has already concluded with the result of going to prosecution or not going to prosecution. Because remember, an investigation that leads to a conclusion that prosecutions are not warranted can also activate complementarity, could also stop the proceedings at the ICC if it's genuine. So that is also important to remember. Now, there could also be another way. As I said, one can appeal the pretrial chamber's decision to issue arrest warrants, and that would go to the appeal chamber. And Israel could also provide evidence that will be new information for the prosecutor that will cause him to reassess his own requests. So there's other possibilities as well. But I would advise, especially for future, and we know there will be future allegations because the prosecutor had been very clear at stating this in several occasions. And we know he's looking at the West Bank. And so I think that, and by the way, he's looking at anything that happens tomorrow as well. It's an ongoing, open-ended investigation. And so I think, if Israel were to at least initiate one or several mechanisms to address all these different concerns, it would be the safest bet, including open-ended, looking at what's going on forward-looking. With the West Bank, I think that's classic for transitional justice, for an alternative mechanism to work as a way of mapping out the events. And I'm happy to go into that if you want.
I think because we are looking at the time, I think what we want to do to conclude this part is to have you discuss transitional justice and the relation between that. I know we've already done it to some degree.
Yeah.
To conclude, I would like you to define it more clearly and then to discuss how it could be related to the ICC.
All right, so I'll take, several definitions of this. I'll take the definition that the ICC prosecutor has adopted straight from the Secretary General of the UN. And this defines transitional justice as the range of judicial and non-judicial measures that states implement in the context of dealing with legacies of violence. And these judicial or non-judicial measures aim to establish accountability while also providing remedies to victims, promoting their healing, promoting reconciliation, restoring the confidence of citizens in state institutions, and strengthening the rule of law. So there's a lot of goals to these mechanisms. The goals go in all directions, right? Accountability for past violations, but also promoting healing, reconciliation, confidence in the state, and rule of law. And these goals are achieved by measures that can be judicial or not judicial, right? And they happen in the context of dealing with violence legacies.
Okay.
We've seen, the most famous example, I guess, that everybody cites for a transitional justice mechanism is the South African Truth and Reconciliation Commission, right? That dealt with all the violations that occurred in the context of apartheid. And that really aimed to heal the society, reconcile the society, but also establish accountability for the crimes, and really promote and really promote also widespread acknowledgement, so that the narrative of what happened is something that everyone will know. So it's about not just finding the truth, but publishing the truth as a way to heal the nation and move forward with reconciliation. So South Africa is the most famous example. There are more than 40 truth commissions in the world that have been established before and since then. And we know in Rwanda, for example, and Colombia, we had not truth commissions, but other transitional justice mechanisms that looked at promoting reconciliation while also establishing accountability after very, very great atrocities, and in order to heal the society and move forward. And how is this relevant to the ICC, though, right? What does that have to do with complementarity? So first, I should say that the investigation that could spark complementarity, so the domestic investigation that a state needs to commence in order to have the ICC stop going forward with its case, is an investigation that has the view towards criminal prosecutions. So it's tricky. I mean, you could have a TRC that has a mandate to refer cases to criminal prosecutions. You could have an inquiry commission like Israel's inquiry commissions have normally or often recommended criminal investigations. And normally, in most cases, this was followed. But again, it's not a must. So for purposes of complementarity, so that a case becomes inadmissible before the ICC, the state has to run an investigation with a view to conducting criminal proceedings. But this is the position of the ICC, by the way. He issued less than 2 months ago his policy paper on complementarity and cooperation. And this is one of the main principles. But at the same time, the prosecutor in that policy makes it clear, and I'm quoting, that this does not prevent the office of the prosecutor and the court as a whole, as a matter of policy, to seek ways and means of integrating and coordinating its efforts along pathways that reinforce a comprehensive approach to transitional justice, incorporating the full range of judicial and non-judicial measures to ensure accountability, serve justice, provide remedies to victims, promote healing and reconciliation. So the prosecutor is saying, look, a TRC alone is not going to activate complementarity. You could have a non-criminal investigation that is mandated to switch into criminal, right? To refer things to criminal system. So you could craft something that's not criminal as something that is a precursor to criminal. But he believes firmly in a holistic approach and will help and coordinate it with states to move forward in a way that has transitional justice approaches in a comprehensive way that promote reconciliation and healing of victims, et cetera. And he's done this in a number of occasions. In the case of Colombia, I have to mention that he's been very advanced with this approach. In the early days when the ICC was doing, when it started its preliminary examination of Colombia, the Colombia conflict was still ongoing. It was before the peace agreement was signed with the FARC. And at that time, Colombia was trying to disarm the paramilitary forces, and they were under examination with the ICC, and the ICC prosecutor has sort of agreed to hold off his own proceedings when Colombia was doing something a little bit alternative. It wasn't a TRC, it wasn't a truth commission, it wasn't amnesties, but it wasn't a full prosecution either of the leaders of the paramilitary forces. It was a procedure whereby in response to leaders of the paramilitary forces coming clean and acknowledging the truth of what they did, in return for that, they would get reduced sentences of between 5 and 8 years. So they're capped at 8 years punishment, and the bottom range is 5. So one for mass atrocities constituting crimes against humanity before the ICC, which are crimes of the gravest concern. The ICC would give 30 years, and other countries might give the death penalty for it or life sentence. Those people can get off with 5 years only if they confess their crimes. And that was approved by the ICC. Later on, when the FARC came into the picture and the peace agreement started moving forward, the peace negotiations, the ICC prosecutor agreed to something even more sort of alternative. And today, the FARC members, former FARC members who come forward and confess their crimes, they might even get community service instead of penalties in a special jurisdiction that is mandated to handle FARC crimes. And this has all been sort of with the blessing of the ICC prosecutor in the sense that he continued to hold off the proceedings against Colombia. And recently, the prosecutor of the ICC said, I'm satisfied that Colombia is taking on this accountability project in a serious way. I am closing my examination of Colombia completely. After almost 20 years of keeping an eye on Colombia, it's closed now. So there's an example. I think with the UK, we had an example in the Iraq situation before the ICC, where UK soldiers or UK leaders were, in principle, they may have been subject to ICC investigations. They were subject to ICC preliminary examination of the Iraq war, and the conduct of UK came under scrutiny of the ICC. And the UK submitted its report that it's doing investigations, judicial and non-judicial, into this. And the ICC prosecutor agreed to close the examination. And he issued a very long and detailed report explaining why he did that, or she, I think at the time. And it specifically says, and I'm quoting, and with this I finish, the UK authorities have initiated a number of this is the reason why the prosecutor closed the examination. The UK has initiated a number of criminal proceedings in relation to the conduct of UK armed forces in Iraq. This appears to include the most notorious incidents, which would likely arise from an investigation of the situation by the office. A number of, listen to this one, a number of other non-criminal proceedings have also brought to light facts that appear to have fed into relevant criminal inquiries. What is he saying here? Because in the UK, there were all these little inquiry commissions, et cetera, that had no criminal, they were not under the criminal justice system. And the prosecutor is saying that it took into account these non-criminal proceedings, these alternative inquiries that brought to light facts that appear to have fed into relevant criminal inquiries. And here is our Israeli case, which could happen, where for the West Bank, for example, or maybe even for Gaza, there could be a alternative TJ, transitional justice mechanism, maybe a truth commission, calling all foot soldiers, calling all settlers, calling all people to come forward, tell the truth about what they did, what they saw, what they heard, what they know, which may constitute a crime. And in return, they may get some kind of leniency, maybe even an amnesty. These are low-level people who will never be like pursued by the ICC. Just tell us what you've seen, what you've heard, what you know. And all this can constitute facts that may be fed, in the words of the ICC prosecutor, into relevant criminal inquiries. It can help map the different crimes. And I think the mapping exercise is something that we don't emphasize enough, and it's very important. The prosecutor himself does this. There's a whole mapping exercise goes on in the context of the preliminary investigation to really zoom in to the problematic days and areas and persons. And this could take years. So something like a truth commission, calling everyone to come and confess and say what they saw and did and heard in return for an amnesty, could serve this mapping project while also helping people heal. And we know, especially soldiers coming out of Gaza, they are traumatized and they may not have a place to talk about things, and they really may want to confess. They may feel that they did terrible things, even if it's not a crime. And they may be afraid to say it because then they might find themselves under an arrest warrant. And so I think a mechanism like this could help this broken society heal from trauma, and people could hear the stories, and not all the stories are going to end up in accusations, but give some kind of an amnesty to these people and help map out the different crimes. And I believe this could be a step in the right direction in terms of activating complementarity at the ICC in conjunction with a more top-down approach of military investigations, which are going on, and perhaps a commission of inquiry, which zooms into the leadership roles.
This would be, this is a brilliant summary, by the way, but just one small question. This has to be proclaimed by Israel today or in the coming weeks, because it would not be able to do that later on.
Yes, the state needs to do this according to the Rome Statute in the earliest possible stage, once a case has materialized. So you can argue at one point, has a case materialized? One could say the farthest in time point, the most future point in time, one could argue is when the trial actually starts, but that is only when the accused is apprehended. So there are no trials in absentia. There are no trials without the accused at the ICC. So if there's arrest warrants, but they never apprehend Netanyahu and Galant, there will never be a trial at the ICC.
And so you would be able to start all those transitional justice mechanisms quite a long time before.
I think it would be hard to argue that the start of the trial is the first opportunity that a state had clarity as regards to the case. I think clarity as regards to the case, you can argue that you will wait for the appeals decision, over the pretrial chamber's decision to approve the request of the prosecutor for arrest warrants. So this could take a bit of time, but it will be very hard to argue that, the state could wait that long. I don't think that any of the leaders of Israel want to have arrest warrants against them because of the restriction of travel, but it also comes with sanctions. So once there are arrest warrants confirmed by the pretrial chamber and later on by the appeals chamber, you will have the state parties of the ICC, almost all states in the world, especially almost all democracies besides the US and Israel. You will have sanctions, you will have Israel blacklisted. I don't think Israel will be able to survive economically and politically in such a situation. So there's no way, I cannot believe that the state will let this happen. But I think where a case becomes one that a complementarity request or challenge will be necessary, it's probably already with the issuance of arrest warrants by the pretrial chamber, but at the latest when it's confirmed by the appeal. So it's not a lot of time. And at that stage, the country or the accused need to argue that there is already an ongoing investigation.
Yeah.
In the Kenya case and other cases, you had accused arguing that there are future investigations for sure going to happen, that was struck down.
Yeah. So I think this is a great time to move to question from the audience. I really want to thank you. I think we've done an excellent summary and then let's start with Ruby.
Thanks very much, Sigal. This was fascinating and fantastic, and yeah, there's a lot to chew on. But I want to ask specifically about the West Bank, but not about settler violence or the things that you were I think referring to in terms of what Israel might or might not be able to do, but in terms of the settlement project itself. Right, the legality of the settlement project itself, where Israel, by definition, can't argue complementarity because that has been an ongoing government policy to establish settlements, and is potentially, under a certain interpretation at least, a crime under the Rome Statute. And I was wondering, I suppose, two things. One, why do you think since 2014 there's never been an attempt to request arrest warrants in relation to the settlement project? Is it because of perhaps seeing it more in a transitional justice context than in a criminal law context? But secondly, do you think it could get tagged on to what is ultimately now a series of arrest warrant requests related to what is happening in Gaza and what happened on October 7th in Israel? So it's part of the same, as you say, situation in Palestine, but is a rather different type of question. And so could the prosecutor do this? Would he do this? Yeah, I'll leave it there.
Yes, thank you. Excellent question. Yes, he could. That's the short answer. But would he? So when in 2021, the former prosecutor of the ICC opened her investigation into the situation of Palestine, she had published also the report, the report of her preliminary examination. So that is the previous step to starting an investigation. And there it was very clear that a few types of conduct were outlined already for an investigation going forward. And there were three main categories of events or conduct that were highlighted in that report. And one of them was settlement activity. So the actual settlement project was named there as a potential, as an area for investigation, which could potentially lead to arrest warrants. The other two was the Gaza War of 2014 and the Israeli response to the demonstrations on the Gaza border, the demonstrations from the Gazan side in 2018, where Israel's response may have been questionable in terms of the ICC. And yeah, so that was out there as a possibility. Now, it didn't move forward to a request for arrest warrants in the last 3 years. It may have. But again, I think that, October 7th and the events in Gaza at the moment take precedent because I think of the feeling of maybe there's a possibility of preventing future ones, ending the current hostilities, ending the strife in Gaza, the hostages situation, and the sexual crimes and the children crimes. So all this takes precedent in terms of the policy of the prosecutor of the ICC. So again, there's always going to be a precedent. There's always going to be priority of ongoing conduct. And I think obviously the settlement is an ongoing project, right? So you could talk about it in that way. The prosecutor has different considerations. Perhaps they want to not interfere with or not destabilize too much the area, but we don't know. We don't know what the considerations are for not having issued any arrest warrants so far regarding settlement activities, but we know that it's black on white in the preliminary examination report of the prosecutor that it's one of the allegations his office is looking into. Again, I think a transitional justice, I've written a blog about this years ago. I think transitional justice would be ideal here. It would show, especially with the project of settlements and not the violence, but the actual project of settlements. Israel will show it doesn't have a law against it, but it's dealing with it through maybe a truth commission. There you might want to hear Palestinians in the West Bank and settlers about each other's pain and subjective experiences, because I think obviously there's terrorism and there are Jewish victims there as well. So you open the whole idea of victims and perpetrators, and the line is not so clear. And you hear everybody's experiences in a process that is aimed to lead to some kind of sustainable political solution that is agreed upon by the parties. So if this is ongoing, I cannot be sure because I'm not the ICC prosecutor, but there is a lot of reason to believe that for that conduct of the actual settlement project, the ICC may back off, knowing that there's a political process, but that is also happening together with an accountability process. Because remember, the ICC is there for accountability, not for peace. Peace, you've got the Security Council of the UN. The ICC is there to fight impunity and to establish responsibility for ICC crimes, that is war crimes, crimes against humanity, and genocide. And so the ICC, if it sees that there's a mechanism that is there for accountability purposes, as well as peace and reconciliation, it may back off from that specific set of events.
One question, a long answer to a very difficult question. I'm thinking whether we have additional questions. I haven't seen them written, or there's a chat question. Is that yours, Ruby?
I think it might have been, yeah.
Yeah, I think it's yours. So is there any other question from the audience? You don't have to write, you can just ask. I think we might have overwhelmed.
I have a question, if that's okay. So again, as a very not legal individual, I mean, it sounds like I'm a psychologist by background. So this idea of transitional justice really sounds like a very healthy approach as well, because like you say, it offers the opportunity to acknowledge the trauma of both sides and kind of process that and let, you know, people talk about what happened to them. So it sounds almost ideal. And I'm just wondering, with everything that is happening now in Israel, with the current government, like, I mean, obviously, Sigal, you have experience in this because you've worked like on different international programs worldwide. Like, are you optimistic at all that this would happen?
I think you would need, I am carefully optimistic.
Okay.
I think, and this is a result of several things. First, the ICC shadow effect, right? So we have it at its maximal. The ICC as, you know, the stick here, and that Israel may want to act in ways that will activate complementarity and put on hold the ICC proceedings. And as I said, transitional justice mechanism could play a very good role there. And I think that is the stick. In terms of the carrot, I believe that bottom-up pressure could be very useful. You see now the bottom-up pressure for an inquiry commission, and that's not new. That's since, you know, October, maybe late October it started. And the idea of looking into what led to October 7th as the subject of an inquiry commission, but increasingly we're seeing requests that the inquiry commission will also look at what's going on in Gaza. Mm-hmm. With relation to the West Bank, you have also voices in civil society drawing attention to the increased violence of settlers in the West Bank. And I think that can also work in ways that ignite thinking about transitional justice in the government. And I think that also the ICC, the stick is there as well, because the prosecutor keeps mentioning the West Bank. In every statement that he made since October 7th, he's mentioning the West Bank. And so I think that's a hint. I think he's giving a lot of hints, you know. And so, yeah, I mean, there's the ICC, the bottom-up process. And I think that there's also maybe new government we can hope for. the next, I don't know, months, that might give this more serious consideration. But also the current government, I think, if they think there's a chance to activate complementarity with the ICC, I think they may want to give this serious thought.
Thank you. We have one more question in the chat. And it might be the last one because I think we're almost out of time. So the question is, what happens if Israel doesn't cooperate? What would be the international scenario, short and long term, and especially with the ongoing recognition of Palestine by various nations?
I think, look, as I said before, I mean, if arrest warrants are being will be issued, I mean, Israel will be ostracized. I don't know what's going to happen with the U.S. approach towards Israel, but if the U.S. keeps an open sort of relationship with Israel, it'll be the only country, more or less. And even then, there's a lot of pressure in the U.S. To change the policies with regards to Israel. So we don't know. But I don't think, economically and politically, Israel can afford that. We'll see a new government, and we waited for Charles Taylor. I worked for the Special Court for Sierra Leone in 2003, 2004. We had indictments issued and arrest warrants against former Liberian dictator Charles Taylor, and it took years to apprehend him. The court had dissolved by then. It basically had to reconstruct itself to try him, and so you might find that when the time is right, the two current suspects are handed over, and that's that. But again, we want to prevent more accusations and more suspects going forward. And in terms of the recognition of the state of Palestine, I think it's a political statement. While it may not have effects in practice in terms of making Palestine a state, but the political declaration of a state recognizing Palestine at this point in time just shows you that all those states are going to be the first ones to boycott and sanction Israel in the case of arrest warrants. Yeah.
I see that Sheldon's raised his hand, and maybe that would be the last question.
Yeah.
So please, Sheldon.
And hey, can I just, okay, let's.
Do you want to finish, Sigal, and then
Before Sheldon, in case this doesn't come up, I just wanted to say another thing. If there is a TRC or some kind of a TRC is the acronym for Truth and Reconciliation Commission, if there is something like this with like truth, acknowledgement through truth, accountability through truth, not so much criminal justice, such a thing, especially if it has a binational kind of component, Israel, Palestine, etc., could also activate Article 16 to the Rome Statute, and that is an article in the Rome Statute that gives a mandate to the Security Council of the UN to freeze for 1 year ICC proceedings in the name of peace. So with peace processes in mind, now we're not going to have a peace process so fast, but if we have a thinking about some kind of a collaborative transitional justice mechanisms, which could lead to peace definitely, or could be part of a peace negotiation process, that in itself may inspire the Security Council to ask the ICC. It will justify a request by the Security Council to the ICC to hold on a little bit or hold off a little bit, because there's something going on that may stabilize the region, that may bring peace, that may bring reconciliation. So that's another kind of motivation, Article 16 of Rome Statute. Yeah, sorry, Sheldon.
I want to be quite clear what you're saying about complementarity. From most of what I've read, many legal experts are saying the fact that Israel is already investigating, 55, I mean, last week it was 75, it's gone up, cases of potential war crimes, the fact that there are cases in front of the Supreme Court about the access of aid, the fact that we have a history of prosecuting prime ministers and presidents, and Netanyahu is in fact facing three indictments in court. But that is not sufficient complementarity, that you have to provide evidence against, which is clearly common sense. And what you seem to be suggesting is that the Commission of Inquiry into the start of the war and so on should be expanded into the conduct of the war. To do that while you're actually fighting a war, it would be quite unique, would it not? So I'm wondering, how feasible do you think it really is for an investigation, which is still very amorphous at the moment, to declare its intent to expand its remit whilst we're in the middle of a war? Is that really feasible? In 3 weeks?
I mean, I think your question has already incorporated the answer, because you said there's 55 ongoing investigations into alleged war crimes in Gaza at the moment. So somebody's doing it. So it's possible. And I think that if you marry that with some kind of bottom-up truth-telling and truth-finding process, which encourages those who come back home from the fighting, and remember, a lot of them are reserve people who come back home for a few weeks before they go back in, or don't go back in because they're too traumatized. But if you have a process that is complementing the military investigations and the inquiry, if it's established, the state inquiry commission, if you have some kind of bottom-up information coming from the bottom, the soldiers, what did we see? What did we do? What did we hear? What do we know? Which, because of what you're saying, the fog of war, et cetera, is very hard to arrive at all those information. And I think that would complement the military's efforts at the moment to reach all those incidents. You'd have lots of information feeding into a potential investigation. And I don't think that you need to see the end of the process at the moment, but you need to start it. So it could be ongoing. And we've had in Israel commissions of inquiry that worked for about, I think the Ofer Commission was 3 years. We may have had even longer ones. And definitely, if you talk about alternative transitional justice mechanisms as truth commissions, they're often working for over 2-3 years and more. And so I think the thing is to start it and to be genuine about it. And that's sufficient. So yes, it's possible.
Have you discussed this with the legal authority? Have you discussed this with the real legal heavyweights in the system in Israel? I mean, the people that are giving the independent legal advice to the government, because of course the two have been at loggerheads, it's quite clear. But have you put this to them, and what do they say?
Well, if I have, I probably couldn't say anything here, but
Yes.
Yeah, I think it's a good time to stop, Sheldon. These are really complicated issues, and we want people to go to further depths here. And I would really like to thank everybody who came and who were with us and with Sigal. Sigal, thank you for an amazing presentation. As always, I really in depth of your talent and expertise. So thank you so much.
Thank you very much for the opportunity. Happy to be here.
Okay.
Thank you, Sigal. So as mentioned in the beginning, we've recorded the session, and everybody that signed up to the Zoom will receive a recording. So you're welcome to rewatch. There was a lot of complicated information here, so we can process. But thank you so much, Sigal and Ofer. This was fascinating. Enjoy the rest of your Sunday. Bye.
Thank you.